it's time for questions. So I'll be in your hands on this one in terms of how much time we want to take. But we've had a range of different presentations this morning dealing with the past. And if you just state who you are and who you want to address the question to, and I'll take a number of questions in the first round, and then the relative responses can come after that. Okay, and we can answer the questions from the table here. We don't have to take the rostrum. Any questions? Yeah. We have a microphone as well.
Yeah. Thank you, Paul. My name is Alec McLaughlin. My father was murdered along with 14 other innocent men, women and children in McGurk's Bar on the 4th of December 1971. Our question concerns two of the panel at least. First of all, I'd like to ask Dave Cox, you finished with our report on the 6th of December 2012. To my knowledge, the first time I met you, you said that the families would be forced to get the report. You in turn sent a report to the Ombudsman's office, Dr. Maguire, who in turn sent it to the Chief Constable, Matt Baggett, who still has this report. Now, I'm asking Mr. Larkin, could you put any pressure on Mr. Baggett to release this report? We have been going on for 7 years from 2006 with this report. Our question is, why has Matt Baggett still got our report after the HET finished with it on the 6th of December 2012? I have here, which we presented to the panel, it's a brief outline of from the start of our complaint to the HET and the Ombudsman's office. So if you would, Mr. Cox, please explain to me why you sent the report to Mr. Maguire, who in turn sent it to Matt Baggett, who in turn still has it from the 7th of February this year. Thank you.
Thank you, Mr. McLaughlin. Clearly, that in itself is calling for an investigation, but each of the panel members will have an opportunity to respond in a moment. Next question, Brian over here. Oh, Kieran. Kieran and then Brian. Go ahead, Kieran.
I have a question for, I think, all of the panellists, really. First one is to the Attorney General. John, you made an interesting remark towards the end about the capacity for the Assembly to pass something.
Kieran, can I just check? Can everyone at that far end of the room hear what Kieran's saying?
You hear me okay? Yeah.
You can, that's grand.
So the first question is to the Attorney General. John, you made a remark at the end of your presentation on the capacity of the Assembly to pass a legislative stay on prosecution, if I heard you correctly. Just if you wouldn't mind expanding on that a little. My question to Michael and Dave is if they could reflect upon what impact the threat of prosecution hanging over the investigations by their respective offices has on the effectiveness of their work, and whether or not, for example, the removal of the threat of prosecution would make their work, either the work of the HET or the Office of the Police Ombudsman, more effective or more easier to do. And my question to Geoff, Geoff, you, in your presentation you talked quite a lot about the scientific aspects of how you've done your work, but also a key part, I think, in terms of the work of your office are the read-across implications in terms of relationships. And you talked, for example, about one person who had been involved in a murder, and that tree line example you gave. So my question is this, do you think that the people that you have engaged in, who I understand are primarily from the Republican movement, have engaged with you in good faith? Have relationships of trust been developed between your office and the people that you engage in? Because obviously a key challenge for all of us in this is whether or not former combatants or former members of the security forces can be relied upon to engage in good faith, and your office is an interesting one that has had a direct experience of that. So that's my question.
Thanks, Kieran. Brian? And I hope you don't have 5 questions.
No, but a couple of comments. My name is Brian Gormley, CAJ. This relates mainly to what the Attorney General was saying. The possibility he raised of a stay on prosecutions. I mean, my understanding is that that doesn't remove the investigative obligation under Article 2. And I'd like his comment on that. I think it's worth also suggesting that the paucity of prosecutions isn't just a question of time passing, but there has also been obstacles and perhaps active obstruction, particularly in terms of historic intelligence material. And I think from a human rights point of view as well, a stay on prosecutions would require an assurance that mechanisms are in place to prevent recurrence, that exposure of past misdeeds and measures in place to prevent recurrence is a precondition of an ending of the prosecutorial kind of route. But the questions which are for any of the panel, in those circumstances, if the prosecution route was ended, what's the extent of illumination that would be required in terms of the investigative obligation? Are we talking about naming names in this kind of process? And if so, or whatever the answer to that, what evidential test are we talking about? Would it have to be beyond reasonable doubt or balance of probabilities? Because it seems to me that illumination of the facts of a case are the least we can expect if the criminal justice route's to be abandoned. But there are a lot of questions about what that might mean in actual practice.
Okay, thanks. I'll take a last question here and then I'll turn to the panel, and then if we have time we'll open it again.
Hi, I'm Kartik Raj from Amnesty International. I had a question for three of the panelists, sort of drawing on what I took to be a common observation, really. Dave Cox mentioned that he felt that you were all looking at the same things, but not in a joined-up way. And I've heard Sir Hugh Ord refer to the work of the Historical Inquiries team as the police's response to what the police could do. Dr. Maguire referred to the Ombudsman's work as only one piece of a jigsaw that is being assembled. And finally, the Attorney General referred to faith and common sense and one other thing I forget, doing their work in a space cleared by law. Looking at those sorts of observations where people talk about the limitations of what each individual organization can do, I'd be keen to hear your reflections on what you believe needs to be done when you're done doing your work. Is there a need for something that looks at your work in the round?
Thank you. Okay, we'll start with response to Mr. McLaughlin. The first issue was with Dave, Michael, and then to John. Dave.
Yes, Mr. McLaughlin. Firstly, pay tribute to you for your patience. I know it's been a long process. The HET has actually delivered a number of reports in respect of McGurk's. We delivered a first report, then we did a supplementary and follow-up report. The Ombudsman's Office produced a report which was then withdrawn, and a second report came out which raised a number of issues for the Chief Constable to consider. The Chief Constable asked the HET to re-examine its reports again, and we have done so. But because we have been examining issues raised by the Ombudsman's Office, it's only right that we then responded via the Chief to the Ombudsman's Office, and I believe that the report actually went from the Chief to the Ombudsman's Office and not from us, because there is an issue between the Chief Constable and the Ombudsman for the Chief to satisfy himself that he's met the recommendations that the Ombudsman has given. My understanding that the whereabouts of the report at the moment is that the Chief Constable has asked Crime Operations Department to review some of the issues referred to in both our report and the Ombudsman's Office to make sure there are no further investigative opportunities, and what the reports say is right in that respect. And I believe that once that is done, then the report will be released. That's my understanding from here.
Michael?
Thanks for your question. I'm not sure there's much more I can add. I mean, as you know, the previous report was issued under the previous Ombudsman that suggested there was further, come back to head for further evidential work to be looked at. I've seen a subsequent draft and I have given my views to the Chief Constable. It's with him, and I don't know when he then will put it forward, but there's nothing more that is for me in relation to this report.
Start with you in terms of Kieran's question. Have the relatives engaged with the Commission in good faith?
Sorry. I think we've always said, when we've been asked, that we've had very significant support indeed from the various Republican movements. You know, the next question I always get is, well, is that 100%? And I really don't know what 100% would mean, but it's certainly been significant. And I think, you know, we have to get this into some sort of context. They too are struggling with the issues that we're struggling with in terms of time, personal knowledge, and in some cases the identities of the individuals who were concerned in involved in these cases. You know, organisations, paramilitary organisations don't keep records, as we all know, and asking somebody what happened 35, 40 years ago is always going to be a tall order. In addition to that, there are a number of non-sanctioned cases on these lists, and by that I mean the centre didn't approve or authorise what took place, and individuals acting for whatever reasons did this without talking to anybody. So again, it just compounds an already difficult problem. I think just to conclude, it is clearly not within the interests of the various Republican organisations to withhold this information. They're anxious to resolve the problem, and I think they readily accept that this was not their finest hour, so that they too want to bring closure here.
Relationships of trust being built up over time, but I think you've addressed that, and that's when I meant the combatants engaging rather than I wrote down relations. So you would say that relationships of good trust have been built up?
They're very sound, and of course the beauty of dealing with the Commission is that the information they provide can only be used to recover victims, so it doesn't go anywhere else. It can't be used for any other purposes, and that has obvious appeals for people who were involved in this sort of activity many years ago. Okay,
David and Michael, the question was, would the removal of prosecution make your work more effective?
Kieran, it's a very interesting question. I mean, fundamentally, it's a question for retired officers because there's a wide variety of reasons as to why officers don't speak to the office. I looked at a case recently and asked for details of two people that I would quite like to speak to, one of whom was dead, the other was in his 80s and at early stages of Alzheimer's. At the other end of the spectrum, there might well be those that don't speak to the office because they don't want to engage in what could be a criminal prosecution. So fundamentally, the issue is, I think, needs to be addressed to them. My view in this is I think it's in the interests of retired officers to speak to the office. I can't compel them to speak, but I do think it's in their interests. But in the absence of them speaking to the office will not stop me coming to a view where I think I've got enough other evidence to make a judgment about things. So I think it's an interesting question moving forward, and it would be interesting to see what the response would be.
Yeah, thanks. On balance, probably it would have a positive effect if there was no threat of prosecution. We don't have a massive relationship with paramilitary groups. Sometimes former loyalist paramilitaries will engage and talk about offences for which they have been convicted. We've not had cases where they talk about other intelligence about former colleagues, etc. We have very, very limited contact with former Republican paramilitaries. They come from a different sort of ethos, I think. In terms of soldiers, we have a wide portfolio of cases where we're trying to trace soldiers who were involved in fatal shootings of civilians. They're very, very difficult cases. The Ministry of Defence is very protective. There are lawyers, obviously. There are it's not just the threat of prosecution that prompts reluctance on the engagement with the HET. In many cases, we're dealing with former soldiers who are in their 60s and sometimes 70s. They don't like the prospect of going back to inquests. They don't like the prospect of the legalistic framework in which a police review is conducted, sometimes involving a caution, sometimes not involving a caution. The whole process is often tape recorded, and it's an issue without a doubt for them. So if you could get to a sort of level playing field amnesty whereby people felt, well, I can engage without any threat to my current state of health, wealth, well-being, then I'm sure it may be useful. But I am mindful that when the HET set up, there was a prospective amnesty issue in the background at the time, the on-the-run legislation which was being talked about, and there was no agreement on that. And I think in some ways you'll find the same issues that we talked about earlier. Should you draw a line under the past and move on, you're going to have a dichotomy of views there, and you'd have the same about an amnesty. But in terms of access to some individuals, I'm sure that the lack of threat of being involved in legal proceedings would be a positive effect for recovery of information for families, but not if the family's seeking a prosecution, no.
Thank you. And what would you propose? Clearly, Geoff, you're working in an area that's quite limited in relation to this, and given that it is so forensic and so scientific, but you might have views on the fact that you've been here for a long time now in Northern Ireland. You've been dealing with families in quite traumatic circumstances. You've probably witnessed all the other ways that Northern Ireland has attempted to go about dealing with the past. And yours has been quite innovative and original in that any evidence given to you could not be used for prosecution. Would you take the view, given the questions raised to the others this morning, that that might be a possibility, that we now look at alternative ways of taking a similar approach to the one that you've been under?
I'm sorry, I didn't get all of that, but I think the gist of it is that I think we have the comfort of dealing with a very, very small set of cases, and therefore have the ability to develop outstanding relationships with families, with the various organisations involved, and everybody's comfortable with dealing with one another because the ground rules are clearly established. I think we're very fortunate, and I can see clearly there are problems for other organisations, for other bodies to adopt this approach, lock, stock and barrel. I'm not saying it's impossible, but there would certainly be challenges, I think, in terms of how that was taken forward. But it has worked, and it's very effective.
Okay. Potentially a challenge, and I know that we have this here, and those who have dealt with the families over the year, but potentially an interesting issue might arise. Did the families ever, having once had their family member returned to them, ever look for anything more? That's an outstanding question, because often people going into this process say that they're looking for the truth, they're looking for the facts, and once they get that, they may want something else. Michael and Dave, given the question to you about a joined-up approach, Michael, are there alternatives to your own approach?
Part of my answer to that question relates to, I think, some perhaps problems or ambiguity that the office has suffered in the past in relation to this. And in a sense, too, I've come at this from the perspective of the office has been given a job to do, and we will do it. But I recognise that it is limited in the context of the overall range of issues that we have to deal with in dealing with the past. That second question, and Brian's, the issues you put forward are indicative of that stage of the debate. It's what is it going to look like? Because each of us will approach that second question, what is the space going to look like, with our own set of tests in relation to will it meet our expectations of what a new process should look like. So what I wanted in the slightly answer your question, is to separate out the role of the office. And it's the office has been given the job to do, and we will do it until somebody tells me not to do it. We will continue to do it. But there's a broader issue about how institutionally we deal with the past and the range of questions and things that we need to address in order to get answers. That is a much bigger question. But I think moving the debate into the space of, well, what would it look like? What would it deliver? What kind of things? What are our expectations of a new approach? I think is the right place to be. But we'll only get there if there's clarity around what we're doing at the minute isn't working, and an acceptance of what we're doing at the minute isn't working, because it's only on that platform can you then say, well, then what would a new approach look like? And then you get into some specifics. Is it time to bring forward Eames Bradley again in the context of an institutional setting regarding to this? Are there other mechanisms that we need to put in place to address some of these issues?
Thank you.
In relation to the tests, I am a bit cautious about change for change's sake if it's not going to deliver something better. And we're very good at rearranging the institutional deck chairs. We're very good at cosmetics. At one point in a previous life, I said Northern Ireland used to launch ships. Now we launch strategies. I think we need to think about what is it going to practically look like and ask a different set of questions to get to the answers.
You're back to the original question that I started my little talk about. What is it that you want to achieve? And for who? One of the issues I didn't perhaps cover is that the HET is actually a very limited structure. We only look at deaths related to the conflict. Victims are a much wider issue than just deaths. Far greater number, and families all impacted to greater and lesser degrees of trauma. So you'd have to have a clear objective of what it is you're trying to set up and what it's supposed to do. And on sort of the lessons, I think, from where we've got to so far, you wouldn't do it the way we've done it. You should have a good set-out strategy before you embark on anything. And I think that's what Michael's trying to say is, you know, whilst what we've got is not by any means perfect, at least it works in its own areas. If you are going to pull it all down and start again or do something different, have a clear objective about what it is you're trying to achieve and for whom you're trying to do it. And don't forget the statutory role that sort of underpins OPONI's work and sets out what they can, can't do and how they write reports and things. So they have obligations. It would have to be a real government-led enterprise, I think. You'd have to sort of start at the high levels and work down, and it would require a lot of research. I think Eames Bradley was a huge missed opportunity. I think they saw a need. They saw a need to join up. It doesn't make sense for us to be doing the same case investigation that the Ombudsman is, but from a different perspective. Yes, we have a good liaison. Yes, we talk to each other. But the issue is that families have to go through 2 lots of interviews and visits. Police officers who we want to trace who might have been involved in the case. We've touched on how traumatic it can be for elderly people going back and talking to them, and they get 2 lots of investigators going with slightly different agenda. So, yes, I would much prefer to see a joined-up approach, but not got to via a piecemeal way.
Kieran is sending me these interesting hand signals, and I don't know if that means do another round. One more round, okay. Or I thought it meant get everybody over to lunch. So he's a hard taskmaster. Paddy, go ahead. The floor's yours.
Hello, I'm Michael Culbert. I'm a former Republican prisoner. I have a wee observation to make here, and then I would like to pose a question to the panel. I found a oneness of approach by the full of the panel when they were speaking about investigating the past. I thought it strange that there wasn't any alternative view on what we're talking about when we're talking about investigating the past. It looks to me like everything started basically when the IRA campaign started. There's no other past to be investigated. I thought it's worthwhile having a wee look at why is there not a context to our past, you know, to the most recent situation where the IRA campaign initiated in 1970. I thought that would be interesting for people to have a look at, to see maybe why the B specials were disbanded, why the UDR was formed and disbanded, why the RUC was disbanded, why even the Housing Executive had to be set up, why the Equality Commission, the Human Rights Commission. The starting point seems to be that everything was okay, and then there was these killings, which was terrible, but I just want to put that in without being aggressive or hurtful to anyone in the room here. That's the first thing. And in connection to it, I thought I would refer to what Louise said at the start of it. It was quite striking. 90% of the people who passed through the prisons were sentenced on statement evidence. And I just thought it would be a reasonable question to ask of the panel, because there's talk about amnesties, but I'm glad Paul McGeehan will be speaking later from the CCRC. Does anyone have any views on the panel of why it is that there was basically no one questioned the legitimacy or the righteousness of a system which allowed so many thousands and thousands of people to be processed through interrogation centres and prisons, resulting in long-term imprisonment on the strength of 90% convictions through the Diplock courts? This is once again, it's just to set an alternative view to it. Does no one think there may have been something wrong? Does anyone have a view on why no one in the power structures of the state, the British state, or even initially in Stormont, thought to query this, or to say there might be something wrong, which may end up in an awful lot of people being imprisoned wrongly?
Okay. Anybody else? The table here at the front, just in front of the, yep. Go ahead.
Sarah Carson. I'd like to address my remarks primarily to the Attorney General. Other speakers previously mentioned his phrase that he used to put a legislative stay, which he initially avoided the use of the word amnesty, but then had a second think about that. I would like to make two observations in relation to that, if you could possibly elaborate a bit more. It would appear to me that you have set aside victims' rights as they are laid out in international law, for example, the right to information and other rights. And there would also be implicit, indeed, amongst the other speakers as well, that international criminal law has got absolutely nothing to do with the conflict in Ireland, and I don't restrict my comments to Northern Ireland. I include the conflict on the island.
Okay, thanks, Sarah. We'll go Jean first, and then in this direction. We've just got the one mic.
Hello, Jean Orr from WAVE, and thank you for a fascinating morning. I, in a way, speak, I suppose, from the work of WAVE and from the many victims. And I can imagine the sort of debates that are going on about amnesty must be tempered with help and support, and continuing help and support for the victims, because there's no way that that would seem fair, in my view. And Monica, you asked about the families of the disappeared, and Sandra's here, of course, who's worked with these families, but I've met a couple of them. And you said, what else do they want? And I know from talking to them, they want somebody to admit that they did this. You know, they do not want the people who did it to continually deny that they did it. And Geoff, you said that you had a good relationship with them. But so the fact that we have found the bodies and so on and so forth, there's still a great deal of work to be done, and I would just caution about still remembering the many thousands of victims and their families and their communities.
Thanks, Jean. There's a question here. Was there someone, just let me, yeah, I'm now getting quite a few questions as we're almost hitting the lunch break. Can we go to this table first, and then I'll go back over to that direction? Both of you can.
Good afternoon. My name is Barry O'Donnell, Justice for Innocent Victims of Terrorism. I'll just keep it brief. Appreciate that we haven't much time left. Just two questions. The Location of Victims Remains Act 1999, is it Article 2 compliant if there's no evidence, forensic evidence, allowed to be given to law enforcement agencies? That's the first question. The second question is really a legal contextual issue. If we're talking about combatants and ex-combatants, are we engaged in Common Article 3, or are we engaged in civil law under UK law? So that would be the second question. Common Article 3, ex-combatants, is it a proper word to use in the context of what we've had during the Troubles?
Thanks for your brevity, Paddy.
Just a comment first and then a question. I find it fascinating the Attorney General should take an antinomian position in relation to the law. But my question is this. In relation to the system of informers which was set up here, which was introduced by MI5 specialist Mr. Walker, it didn't pass through Parliament, and now we read from De Silva that, in fact, there was never put in place any system to make sure that that operated within the law. Could the panel please comment on how they feel that in future we could prevent that sort of antinomian position in relation to the law developing anywhere else in the United Kingdom or elsewhere?
Thank you. I will go quickly over to the back table where they're good, fine, and Daniel, I'll try and get you in if I can.
Mary O'Raw, just actually to pick up on Paddy's point, I do think it's interesting that the comment on law clearing out and clearing space comes from the Attorney General. I think it's an interesting comment on the effectiveness of our administration of justice. And I think it's important to recognise that law got us into this position in very many ways, that it has a part to play in the conflict and in the solution. And I think it's possibly too glib. Nice though it may be, if you think of a whole range of areas, if law would get out of the way and let people get on with building proper relationships, certainly. But given that law has been part and parcel of bringing us to where we are now, surely the emphasis should be on law taking a very proactive and creative approach to thinking about how to facilitate those other ways of dealing with the past, not get in the way of them, not institutionalise institutional silos and all the other problems that we've talked about today. And the other just brief comment in terms of the Assembly legislating in terms of stay of prosecution or whatever else, that not only is the Convention a limitation possibly on its powers in that respect, but the whole issue of national security needs to be taken into account, and that feeds back into Paddy's comment in terms of the use of informers and that whole regime and how the politics and the law played together or didn't play together in terms of turning blind eyes to things that shouldn't have been happening. Thank you.
Okay, I think there was another question at your table, was there? No? Yeah? Okay, not. And finally, okay, on your way back over, take one here and then take one from Daniel, really quick. We may not get answers to all of them, but at least you'll get your point out.
Hello, my name is Peter Heathwood. I'm on the Victims and Survivors Forum, and I would just like to ask the panel what they would comment on the loophole in, especially the HET, where they don't look into the cases of people who were severely injured or those who died of heart attacks at the scenes of violence. In my own case, my father died the night I was shot, and the HET couldn't reopen the case because it wasn't part of their remit. I think that is a loophole in the system, and maybe they could comment on that.
Thanks very much. And Daniel?
Daniel Holtis. CEJ, be very quick. I just want to pick up on Paddy's comments in relation to covert policing and the operations of agents. I think there can be very little doubt after De Silva that agents were routinely involved in forms of serious crime. Dave, you'd raised the issue around the modus operandi of agents and your input, and my question, I suppose, to you is around where your jurisdiction begins and ends in relation to crimes that did involve agents. I mean, I think we know it's sort of Article 2 for beginners, that the police can't investigate the police, and it seems to be quite clear that when a police officer is directly involved in a death, then there will be a referral from the HET to the police ombudsman. But my question is, what happens in relation to cases that come across your purview where crimes are attributable, or there are the implication that agents and, by extension, their handlers are involved in crimes? Thanks.
Okay. I've tried to make a note of which questions are to who. Michael, can I suggest, I know Paul McGeehan and Gordon Anthony are here, I'm not sure if Barra's here, that's something we could actually put to the panel this afternoon, because this morning we were looking at this whole issue of the law and prosecutions. But your question was to widen this out beyond that in terms of dealing with the past needs to be more comprehensive than that. And when did it start? And how did it start? In many ways, what were the causes? Because I think that's a much wider discussion and it may or may not be picked up. In relation to the questions, I think each of the panel members will know which of the questions were to them. And certainly Sarah's, Paddy's, Daniel's, and to some extent Mary and Barry's questions very much lie with you, John. And then this question, which will start, Geoff, briefly, because it is, I think, only requires a fairly brief answer, is Barry's question on the Article 2 compliance, the right to life compliance with your Commission's legislation, the statute under which you were set up. Can you say something about that? Because it clearly, he believes, his question is that how can this fit with the European Court's Article 2 compliance, and that there's going to be no prosecutions based on evidence given?
It's an interesting question, and I really can't, I'm not in a position to answer it. We operate under the legislation set out in the two jurisdictions, and that is that. If there is European legislation that overarches that or compromises that in any way, then clearly it's something we need to think about. But it's not an issue that we've discussed at the present time.
Okay. The issue, Michael, that you deal with also is support for victims, and that did come up. And Jean made the point too that in dealing with the past, one thing that victims want is admission. And perhaps what John has just said is that they may not always get that through the legal process. We talk about admissions and apologies, and of course all of this in the round in dealing with the past. But the particular questions, I don't know if there's anything you want to say in addition to what's already been said that through the round of questions that were asked there in the last round. And very briefly.
Very briefly.
We can smell the food.
And rather facetiously, John talking about lawyers. I used to work for a long time in an accountancy firm, and we used to say that accountants, like lawyers, have their place. You just have to remind them what it is on a lot of occasions. The issue about the context is one I want to pick up on, because I have heard in the context of the work that I'm doing, a lot of talk about context, and we need to understand the context, and your context is different from other people's context. And in a sense, that's part of the difficulties that the office has had in dealing with some of these issues, because our remit is quite specific. It's criminality and misconduct in relation to the agents of the activities of the police. That's what we look at. There are many other facets of the nature of the troubles in Northern Ireland which we do not look at and can't look at because it's outside our legislative remit. Those are part of the debates that we need to have if we're starting to come back to the point that Brian made earlier. If we're starting to frame what a new conversation looks like, we need to make sure that we understand what it is that people want out of a new conversation. The views on the office and what the office can deliver are, and to some extreme, are irreconcilable in many cases. That doesn't mean that we shouldn't talk about it as part of a broader sense of ideas to what we need to do moving forward.
Okay, and Dave?
Yeah, thanks. I'll pick up a couple. There were a couple of issues raised around informants. Firstly, about the accountability mechanisms for running agents or informants, or covert human intelligence officers, as they are now called. It sort of puts me back to my Stevens investigation hat on, going back some years. The relevant guidance which the RUC were operating was a Home Office circular in 1990, which set out guidance only on how agents would be using it. It was all about participation in offences and things like that. There was no legislation until the Regulation of Investigatory Powers Act which I think was in about 2000, which put everything on a statutory framework, and it is much tighter control these days. And also there are other oversight bodies such as the surveillance commissioners and groups like that. So if that helps. In terms of the loophole for severely injured parties, it is a massive loophole. I referred to it earlier, victims. It's a much wider concept than just those who died. In terms of the jurisdiction of the HET, looking at cases involving agents, we do those cases. They are the deaths that we're looking at. If we come across issues of concern in respect of police handling of agents, those issues are referred and have been referred to the Ombudsman's office. But we will still do a review of the death, albeit that there is an agent possibly involved. Another big area of work for us is where alleged agents were themselves murdered, and there are in excess of 100 cases throughout the course of the Troubles where paramilitaries killed people on the basis that they suspected they were agents, and they also need some pretty delicate handling because of the stigma that attaches to the families. In many cases, the families still living with the stigma of that. So they need a lot of careful work and a lot of sensitive handling. And again, I'd pay tribute to WAVE for the work that they do with us in all those cases. And lastly, for me, just around the legitimacy of the system, the gentleman at the front was, I think it is perhaps a wider issue. The HET's remit is just deaths, and it is set by budget and by the policy of the NIO, just to look at the deaths associated from 68 to 98. So we don't go beyond that. And in terms of statements and things, well, that was the policing practices of the day. It was before the advent of taping of interviews and the Police and Criminal Evidence Act, which came later. And it wasn't just Northern Ireland, it was across the UK. Whether it was right or wrong is for a wider debate.
Okay. Thanks very much, everyone, for your participation and for your patience. The lunch is now. We're due back at 2 o'clock. And on your behalf, can I thank the panel very much for their contributions and for taking time to answer the questions so thoughtfully, and in particular to Geoff, who flew in especially for the conference today. Thanks very much.